First up is Matt Fischer of Snell Wilmer's Phoenix office. Matt is a commercial litigator focusing on real estate, securities, IP, international litigation, as well as agency, regulatory, and administrative matters, FINRA and AAA arbitrations. He represents financial institutions, broker-dealers, retail and investment banks, lending institutions, and investment advisors in federal and state courts and SRO arbitrations. Matt has worked with FINRA and the SEC and other administrative agencies on broker registration issues and responses to regulatory inquiries. Matt will discuss the latest developments in arbitration discovery. Please welcome Matt Fischer.
Thank you, John. And good morning, and if you're not paying careful attention to your watches, I have the honor of being the last presenter of the day to wish you a good morning. I'm going to be covering the developments in discovery and FINRA arbitration. Got the clicker, thank you. And I'm going to be hitting 5 subtopics. The first is going to be going over the changes to the discovery guide in 2011. They've been in place for a couple of years, so I'm just going to hit it on a high level. But I did want to cover it just in case you've been lucky enough to avoid customer arbitrations recently, in which case if you're a broker-dealer, all of your branch managers should get an immediate raise. Second, I'll be covering the changes to non-party discovery. Those are the changes to the procedural rules applicable to orders and subpoenas. And then we'll be checking in on the status of FINRA subpoena enforceability against non-members in federal court. And then we'll review the currently proposed changes to the FINRA discovery guide. And then I'll provide an update on DR Portal, which is FINRA's new e-filing system. This is really more administrative than discovery, but I wanted to let you know it's coming if you haven't had the opportunity to experience it yet. In 2011, FINRA overhauled the discovery guide, undergoing its second change since its inception in 1999. The document production lists were previously broken down by claim, and so for each particular claim alleged, you would produce the specific categories of documents listed with respect to that claim. For example, if churning was alleged, you would have to produce commission runs. With the overhaul, FINRA eliminated all of those claim-specific lists, and now you have one document production list for claimants and one document production list for respondents, and all of the document categories are presumptively discoverable in every customer dispute. Given this change over the past year, we have found that arbitrators are more receptive to objections to producing documents listed, whereas before they were presumptively discoverable and it was somewhat difficult to get an arbitrator to say that you didn't have to produce everything on those lists. But now, for example, objecting, say, to the production of commission runs in a failure to execute case, arbitrators and arbitration panels have been more receptive to those types of objections. The overhaul of the guide also changed the document production list themselves, for the most part expanding the categories of documents that you have to produce, although in some instances eliminating a few things. Some of the primary expansions of documents that firms now must presumptively produce include telephone logs, advertising materials, a broader production of customer complaints and disciplinary history. And some of the primary expansions of documents that claimants must produce, research reports, other settlements, and broader production relating to correspondence and investment materials, regardless of the source of those materials. Notably, customers are no longer presumptively required to produce other complaints involving securities firms or investments, or any documents relating to mitigation. To the extent those documents exist, we tend to find them probative, so we will typically include those in our separate request for documents. Most of you have probably already adopted to the new discovery guide, but if you haven't been involved in a customer dispute lately, make sure you're using the most recent version. And now turning to the changes to non-party discovery in FINRA. Non-party discovery is done through two vehicles: the order, which is issued to member firms or associated persons, and the subpoena, which is issued to non-members or those outside of the industry. Previously, the code outlined virtually no procedures for orders whatsoever. The code had no express mechanism for non-parties to object to either subpoenas or orders. Cost reimbursement to member firms by propounding parties was provided for in orders, but not provided for in subpoenas, which sometimes led clever counsel to strategically use subpoenas when seeking documents from member firms instead of orders. And FINRA addressed these issues this year in its regulatory notice 1304, adopting new Code of Arbitration procedural rules for both orders of subpoenas effective as of February of this year. The changes apply equally to both the industry code and the customer code, and the changes apply equally to requests for document production as well as for the appearance of witnesses for testimony. The new rules also create some level of consistency between the procedures for both orders and subpoenas, and the rules require the use of orders in the event you are seeking documents from member firms or associated persons. There are a couple of exceptions to this. You can use a subpoena instead of an order if a member or associated person has failed to comply with a previous order, or if, for example, an associated person has left the industry, but it's basically limited to instances in which a prior order has been ineffective, or it's anticipated that an order will be ineffective. Turning to the new procedures relating to orders, which again is how you obtain documents from member firms, virtually all of the procedures and the rules are new. To issue, a propounding party files a motion along with a draft of the order. The opposing party has 10 days to object. The propounding party has 10 days to respond, and the arbitrator rules. And the arbitrator can issue that order in the form it was proposed, or oftentimes they will modify it to address the concerns raised by the opposition, or may deny it wholesale. And when I say arbitrator, I'm talking about the panel member who is responsible for deciding discovery-related motions, which is almost always the chairperson. These issues aren't brought before the entire panel. And in my experience, the chair will usually rule on these motions without a hearing, as opposed to a motion to compel situation where you may get a discovery conference or pre-hearing conference from the arbitrator to have an oral argument. In terms of the non-party response, again, a new set of procedures. The recipient non-party who has received the order has 10 days to object. The propounding party has 10 days to respond, and the arbitrator will rule on any of those non-party objections. After the production is made, within 5 days, the party responsible for issuing the order must notify the opposition of their receipt. Watch for this. Typically, you don't get that, but the opposing party can then request copies of the documents, and there's no time restriction on that. It could be done within a week of production or within 3 months of production. And then if you're the party that's received the documents, you've got 10 days to provide the documents to the other side. Of note, the propounding party, and this was true before, but the propounding party pays the reasonable costs of the non-party member. Our practice is to get out in front of this issue and authorize in a cover letter the party to incur up to X dollars in costs in making the production, X being what we've reasonably determined is an estimate of what the cost is going to be. And if the party that we've ordered to produce documents anticipates going over that dollar limit, then we ask them to contact us and to discuss the matter to see whether that amount can be reduced or perhaps the scope can be reduced in order to keep things within budget. The procedures relating to subpoenas, which are again used for those outside the industry, for issuance they are essentially unchanged and are now what is reflected in the order procedure. Basically, motion with a draft subpoena, 10 days to object, 10 days to respond. What is new to the subpoena rules are the procedures relating to non-parties' ability to respond, and really what these are more of a codification of what was practically happening in the arbitration context. And again, they're the same as they are for orders, 10 days for an objection, 10 days to respond. But because non-members are not subject to FINRA regulatory authority, even if an arbitrator overrules a non-party's objections, without voluntary compliance, going to federal district court to obtain an order compelling the production may be necessary, and I'll talk about that a little bit more in a bit. The post-production procedures are the same: notice of receipt in 5 days, production upon request in 10 days, and the propounding party reimburses reasonable costs of non-party members, so in those instances where the subpoena was appropriate as to a member, but there is still no presumption that the propounding party has to reimburse the costs of a non-party non-member, in other words, someone outside of the industry. Now, in practice, non-members will raise the issue of cost with the arbitrator, and the arbitrator will entertain that issue. But oftentimes, as a propounding party, offering reimbursement is used as an incentive to obtain voluntary compliance from someone outside of the industry, which is a good transition into the next topic, which is the enforceability of these FINRA subpoenas issued to non-members. And there has been and continues to be a split of authority between federal circuits as to whether a pre-hearing subpoena for the production of documents is enforceable against someone outside of the industry and outside of FINRA's regulatory control. And this stems from a debate over the interpretation of the language of Section 7 of the Federal Arbitration Act, which is from where the arbitrators derive their authority. And the split is basically the Sixth Circuit and the Eighth Circuit will enforce these subpoenas. The Second Circuit and the Third Circuit will not enforce them. The Fourth Circuit uses a balancing and hardship test. And the only recent decisions that relate to this issue have come out of district courts in the Seventh Circuit, which, based on their analysis, suggests that if the Seventh Circuit was to address the issue, that they would side with the Sixth and the Eighth and enforce the FINRA subpoenas. Now, the U.S. Supreme Court has not yet had an occasion to address this split and probably won't anytime soon. So in sum, whether or not you can enforce these subpoenas depends on the jurisdiction that you're in. And of particular note, it isn't the jurisdiction where the party is that you've subpoenaed. It's actually the jurisdiction where the panel or the majority of the arbitration panel sits. And so where your case is pending may make a big difference as to whether you can enforce these subpoenas against someone anywhere, because it depends on where your panel is. Turning to the proposed changes to the rule that are on their way, SR FINRA 2013-024 has been filed with the SEC and was in June of this year. And that proposal seeks to amend the discovery guide in 3 ways: e-discovery, product case designation, and affirmation. The comment period for that proposal has expired, and those rules did generate quite a bit of input. But other than one small change to some language, FINRA made no significant amendments to the proposal, and the proposal is now slated for SEC action. it is safe to say that the new rules that I'll be describing are on their way. The first is that, and this is a big one, e-discovery is coming to FINRA. Parties are encouraged to discuss and agree upon the form of production for electronic documents. The panel decides any dispute, and so doing takes into consideration a number of factors, including the form in which the document is ordinarily maintained, whether if it was provided by a non-party, the form in which that party provided it, reasons for conversion, how the documents might be affected, whether the utility is diminished, and underlying all of this analysis is the requirement that electronic documents be produced in a form that is reasonably usable. What we're really talking about here is possible production of electronic files in native format and the possible production of metadata. And the effect of this coming rule is really on the front end. If production might be required in some cases, then preservation is necessary in all cases, because you don't know in which instances a panel or a party is going to require production. And this presents a very significant paradigm shift in FINRA arbitration away from cost efficiency towards more burdensome discovery, and ultimately e-discovery may mimic civil litigation that we're used to seeing in regular court. The days basically of print and forget, print and provide to your outside counsel and not worry about it anymore are probably coming to an end. The new e-discovery rules will need to be accommodated and hold memorandums upon notice of an arbitration action. Preservation in electronic form will be necessary, and in some instances, production of forensic copies are going to be necessary. This will probably increase the use of outside vendors by broker-dealers in order to manage this electronic information. The second change is the creation of a product case designation. This applies when claims center around widespread mismarketing or the defective development of a specific security or a group of securities. And parties may request the panel to make a designation of the FINRA arbitration case as a product case. And the purpose of this is to acknowledge the difference between the nature of a product case and other cases. In product cases, oftentimes you're dealing with larger volumes of documents, multiple investors, documents that are not client-specific, a greater likelihood parallel regulatory investigations or parallel class actions, some documents being produced to numerous parties, and analyses being performed by people within the firm that had nothing to do with and did not handle the customer's account. Now, if the arbitrator designates an arbitration as a product case, parties are not limited to the document production lists in the discovery guide. Not that they really ever are, but an arbitration panel in a product case is going to be willing to consider much broader and more numerous requests for documents. So if you have a case that's designated as a product case, you can anticipate requests asking for documents relating to creation of the product, due diligence reviews of the product, training on the product, marketing of the product, and post-approval review of the product itself. The third change is for affirmations. Currently, a party who produces documents in response to a category or has no documents to produce has to provide an affirmation that they looked and they couldn't find anything. The new rules are going to provide for affirmations required in partial productions, as well as a requirement to state the particular sources that you searched when you did so. And so search logs as to who searched when and how and what electronic terms were used are going to be more important. And finally, DR Portal is FINRA's arbitration electronic filing system, essentially the equivalent of the federal court PACER system. Currently, we're in a pilot program where a few member firms, I think it's 4 and their outside counsel, are filing through this. I find the system to be fairly effective. I provided some of the DR portal materials in your guide, although those will be updated once the bugs are worked out and the filing system is rolled out industry-wide. Thank you very much.